Good morning, Mr. Hardy.
Good morning, how you doing?
Mr. Hardy, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. Shh. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge.
Okay.
On November 22nd, 2024, the officer observed the defendant's vehicle parked more than 18 inches from a curb on a public roadway in the right lane of a two-way road in Harris County, Texas. While the officer ran the motor vehicle, the passenger side door opened, a black female exited, and the female approached the patrol vehicle. The officer made contact with the female and observed a strong odor of marijuana emanating from the female. The officer made contact with the defendant, the driver of the vehicle, and observed a strong odor of marijuana and had the defendant exit the motor vehicle. A PC search was conducted and the officer located 3.5 in the driver's side door and one blue package with Oops All Berry on the front containing green leafy substance on the rear driver's side floorboard, one red package with Fruity Pebbles on the front containing a green leafy substance in the back seat, and two clear plastic baggies containing green leafy substance under the front right passenger seat. The officer also observed one burnt marijuana cigar behind the front passenger seat and one small chunk of loose green leafy substance in between the driver's seat and the door. The green leafy substance was identified as marijuana based on training experience, and the weight was 54 grams or 1.9 ounces.
He was doing what that was wrong?
So he was parked more than 18 inches from the curb on the right lane of a two-way road. So he was out.
On earth are you going to know that you're parking more than 18 inches? What time of day or night was this?
Your Honor.
Is it parking while black now? Come on.
Yeah.
Your Honor, there's no time listed. It just says the officer was on patrol around the 3518 block of Arbor Glen Drive when he observed the vehicle parked more than 18 inches from the curb.
And so he goes up to the car because of that?
No, Your Honor, a female passenger side exited the passenger side and approached their vehicle, and he observed a marijuana from the
Because he comes up to them. Right? Stop. Are you losing?
The officer wrote as he ran the vehicle, presumably the license plate.
Right, he pulls him over.
They were already parked on the side of the road 18 inches from the curb, and he came, I guess, parked behind, and he was running the vehicle, and then the passenger side door opened, a black female exited and approached his vehicle, the patrol vehicle, and he observed an odor of marijuana on the female, and then he made contact with the driver, where he observed marijuana odor in the vehicle. So the female approached the patrol vehicle.
Show me in the penal code that code. What is the penal code for that?
Regarding the 18 inches from the curb, sir, is that the issue of what we're talking about?
Yeah, because they come to him because he comes to them. Right, they're just parked. He comes to them. It's got to be a transportation code, not penal code, you know?
And Your Honor, regarding the timeline of events, it does appear that when they were parked that distance away, which could be arguably further, I don't know what it looked like at that time, but the female passenger is the one who exited first, and that was before officers ever made contact with them. So I don't know if you were thinking that the officers approached them first, but I just wanted to clarify that she approached first.
What time of day or night was this?
Trying to see that, Your Honor, in a second. Is it 4 in the morning?
And Your Honor, I
4 in the
found,
morning.
4:30 a.m.
And you can delineate at 4 in the morning that parking 18 inches from a curb.
and I found the regulation, the statute in the
Mhm.
transportation code where it says you have to park within 18 inches.
At 4 in the morning, you can tell.
Your Honor, the officer was,
Yeah.
yes.
I don't think so. All right, I'm going to find no probable cause.
Yes,
All
Judge.
Guys, be careful, right? You know, they're always out there. Just be careful. Do something with your life. Knowledge is power. Get into school, get an education, do something with your life. Life is hard as it is. And it only gets more difficult the older you get, all right? Okay, guys, please. Good morning, Mr. Sarmiento.
Ese es señor Sarmiento.
You were,
Bien, señor Sarmiento.
you were charged with criminal trespass. You are facing up to 6 months in jail and or a $2,000 fine.
Dólares de
We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney appointed if you cannot afford one.
multa. Si no puede ocupar una.
Yes, Judge.
I'm going to go slow.
Yes, Judge.
Más escucho.
On January 5th, 2025, the officer became aware of a stolen vehicle via a flock alert. The flock alert was for a listed stolen blue Hyundai. The officer checked the vehicle's license plate and observed the vehicle stolen as of December 21st, 2024. The officer observed the vehicle turning northbound onto East Tex Freeway, taking the ramp heading north on East Tex Freeway, and ran the license plate, confirming the vehicle to be stolen. A traffic stop was initiated. The officer announced themselves as HPD while giving command to turn off the vehicle and place hands out of the vehicle. The defendant, the front passenger, was the last to exit the vehicle, and the officer made contact with the complainant, and the complainant stated he did not know the defendant, did not give the defendant authorization to operate the vehicle.
What?
So they found the stolen vehicle, Your Honor.
How does he know that it was stolen?
And Your Honor, there's no need for him to know this vehicle. There's no requirement he knows, only that he's in the vehicle without permission from the owner. And the owner said he does not have.
How does he even know that the person driving stole the car?
Well, he doesn't know the defendant. He doesn't know, he didn't say he know he stole it. He just didn't know him, did not give
So
permission.
you're telling me that he's in a car, he doesn't know the driver, and
Right, the complainant just said that in regard, he did not know the defendant, did not give.
I understand that, I get that,
Yes.
but, so he's he's a passenger in the car, and they charge him with criminal trespass. And in the DIMS, it says that he doesn't even know the driver. So how would he even know that the car is stolen? How do they know each other? How, I'm beside myself. I don't. When a criminal trespass requires some kind of like notice that, hey, man, you know,
So the trespass was the driver driving into the area and he was the defendant.
he's the passenger, right? I would assume that the driver got charged with UUMV.
Let me see what he got charged with.
If you tell me no, I'm gonna lose it. Really?
Yes, Judge, UMB.
Okay. But the problem is that like, how would he know that the car is stolen? Right? You got to give me something that, it's a specific intent crime. You have to, you know, there's got to, in my opinion, you've got to somehow know that the car is stolen. And
In Your Honor, further, I guess to get to that, he was in a relationship with the defendant who was in the vehicle, and there were signs of damage to the vehicle that the officer articulated, saying that there was, one moment,
a scratch on the hood.
signs of theft that would lead a reasonable and prudent person to believe the vehicle was stolen, as the steering column was broken in a manner that only a screwdriver could turn the vehicle on, and the screwdriver was tagged into the evidence. So there was damage from a screwdriver in the vehicle indicating that it was stolen, and this defendant was in a relationship with the driver of the vehicle. That, and then furthermore.
Did you just tell me that they didn't know each other?
No, the complainant does not know the defendant.
Oh, okay. But I thought you also said that the driver and,
No, Your Honor, and it may be misunderstanding because of me, but it's the complainant saying he does not know this defendant and did not give permission to the defendant to operate the vehicle.
so there's enough there that a reasonable person would believe
At the,
he's in a stolen car.
Stolen, yes.
So the steering column, was it?
was broken, and the officer said that in a manner only a screwdriver could turn the vehicle on.
del vehículo.
See, I don't know, because when I was young and dumb and 17, and, my friend had a CJ7, you ever been in those Jeeps that are just jalopy Jeeps, right?
Yes,
They
Judge.
always broke down. They always had a problem. We always, Jimmy rigged it as well.
In this case, Judge, I believe there would be enough for PC because we have a vehicle with evidence of breaking into the vehicle with that damaged steering column.
I've been in vehicles like that before.
And we furthermore have a complainant saying he doesn't know the defendant in the vehicle.
No difference to me.
That goes to the element of for the criminal trespass, it goes to with knowledge that it was
Nah, no, I'm sorry. I'm gonna find no probable cause. I'm sorry.
Porque no hay razón probatoria.
Be careful. When you hang with dogs, you get fleas. I don't know what your status is in this world, if you're in this country with permission. But if you go to jail and you're not in this country with permission and you spend any kind of 4+ hours in there, immigration will put a detainer on you and you will be stuck like Chuck in there until you get shipped to immigration. So live like a halo, especially if you're not well documented in this country. Go ahead, one will be appointed to you, sir.
On May 23rd, 2023, the complainant made a report that his scooter was stolen and it was worth approximately $600. The complainant provided the serial number. On August 5th, 2024, the officer received a hit from Leads Online, which noted that the defendant pawned the scooter. The officer went to that easy pawn location at 12303 Bel Air and met with the complainant, who stated that the defendant pawned the scooter for $100. The complainant was able to provide the officer with the defendant's driver's license, and surveillance video showed that the identity of the defendant matched the video.
Yeah,
The
but
driver's
you know that
license.
he took the scooter from the place, from wherever it was, how do we know that someone didn't give it to him? I get it that he's pawned. I mean, perhaps, possession of stolen property, but theft.
So the allegation is the complainant is not the owner of the scooter, it's a pawn shop. So the allegation here is that the defendant,
Well, he's charged with theft, right? So he has to steal it.
by acquiring or accessory. Well,
Right, you have to acquire.
yes, Your Honor. I'm reading
So
the-
here, all he's doing is he's pawning it.
Ramsey?
It's a specific intent crime, so we have to,
The intent to deprive the pawn shop. So I think
well, the pawn shop is not it's the person who owned the scooter, which would be Mr. Elatari. That is the actual complainant because it's his scooter that gets stolen, but we just don't know who steals it. We know that he pawns it, right? And we get these so much and it just, the problem is that the legwork would be somehow, okay, we get it, go back to the complaining witness and then somehow see if is there a ring video that sees him stealing it, then, so, right. It is what it is. Mr. Salinas, I'm going to find no probable cause in your case. Please be careful. We're not asking for much. All we want our streets to be safe. You know what I mean? All right, please.
3 probable cause hearings in Judge David Fletcher's courtroom, where all charges were dismissed due to insufficient evidence. Case 1, marijuana possession. The judge ruled the initial police approach was unjustified based on a questionable parking violation, making all discovered evidence inadmissible. Case 2, criminal trespass. Passenger in stolen car. The court found no proof the passenger knew the car was stolen, which is required to establish intent. Case 3, theft. Pawned scooter. The defendant pawned a stolen scooter, but the 15-month gap made the recent possession inference invalid, and no direct evidence linked him to the theft. Overall, Judge Fletcher found no probable cause in all 3 cases, emphasizing that arrests must be supported by clear, lawful evidence and not assumptions.